Wow, this new invention sure is great. I can't wait to release it to the world. Well, what do we have here? A competitor. No, I'm not sure if he's actually done anything wrong, but just to be on the safe side, I think I'm going to sue him for breaching my patent. Oi! You! I've got a cease and desist letter with your name on it. Cut that out! Not so fast. You didn't see what I was writing about. Oh no! Hi there. You're probably wondering, why was this guy so scared of a piece of paper talking about Section 128 of the Patents Act? Well, it's because this section allows people or companies that feel like they've been threatened with a lawsuit for patent infringement that doesn't have any real basis taking legal action. The law is particularly focused on people who try and restrict their competitors by making baseless claims against them. In other words, it looks like this guy might be in big trouble. So when talking about the unjustified threats provision, we're going to want to know about three things. We'll need to know when a threat has been made, when it is actually unjustified, and what the consequences are for making one of these unjustified threats. Now, obviously not every unjustified threat is going to be as blatant as what we saw before. Oi! You! I've got a cease and desist letter with your name on it. Cut that out! So where do we draw the line? Basically, it all boils down to the circumstances of the communications. Now this can get considered objectively by the court, and basically it boils down to what a reasonable layperson would decide. Would the language that got used in the communication make you think that they intended to take legal action against you? In one case, this involved a company sending emails to their customers, saying that they had taken an alleged infringer to court, and that they were considering taking action against any of their customers if the court held that the patent had indeed been infringed. With that being said though, just notifying someone that a patent exists, or an application for this patent, doesn't actually constitute a threat of proceedings. So if I just told you that a patent existed, I haven't actually threatened you with anything, so I haven't made an unjustified threat. Well, now that we know when a threat has been made, when will the law actually say that it's unjustified? As the name suggests, it basically boils down to situations where the patent owner cannot actually make out a case for an infringement of their intellectual property. Conversely, if a patent owner can show that their rights were actually infringed, their threats, of course, will be justified. So if these two things are fulfilled, and an unjustified threat has been made, what's the court actually going to grant you? Well, there's several reliefs that the court are able to impose in these situations. Firstly, they can make an official declaration saying that the threats are unjustifiable or groundless. They can also grant an injunction against the intellectual property owner, which is basically just a warning, asking the other party to stop threatening lawsuits. Finally, the court is able to award damages for the loss that got suffered as a result of the threats. This can, however, be quite hard to show. There must be a connection between the threat and the loss that was suffered, and you have to be able to prove that. So there you have it, the unjustified threats provision of the Patents Act. Now you know when a threat is made, when the threat will be unjustified, and what relief the court might grant in these circumstances. Hopefully this has helped you out.